Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today is part 2 of our series on tort law, and today we are looking at intentional torts. So head on down to the beach and follow along. Let's talk about intentional torts. Intentional torts are those torts that are essentially an act where somebody intends to do the act. Now, they might not intend to do harm, but they certainly intend to do the act. How many of you have seen a parent or someone raise their hand up to a child and seen the child shrink back and the child, whatever the child was doing that was annoying the parent, the child stops? Well, if you do that with an adult, another adult, and you draw your fist back and you make them appreciate the fact that any second now you could take a punch and hurt them, you are committing the tort of assault. And the intent may not be to inflict harm. The intent may be to get somebody to stop what they're doing. But irrespective of that, there is an intentional tort called assault. In addition to assault, there's battery, which is actually hitting someone. It is a harmful and offensive contact, I believe is how the law refers to it. There's trespass to land, trespass to chattels, defamation, intentional infliction of emotional distress, which we'll get to in a moment, and fraudulent misrepresentation, which we'll also get to in a moment. So let's look at the tort of assault first. An assault is a threat of bodily harm to another in such a way as to leave that person in fear of physical contact. Now, not all threats are assault. Two elements have to be there. The act was intended to cause apprehension of harmful or offensive contact, and the act indeed caused reasonable apprehension in the victim that harmful or offensive contact would occur. Now, assault is indeed a tort, but it's hard to get damages just from assault because people rarely suffer any harm as a result of an assault other than maybe being scared for a few moments. But there is a provision in the law to award damages for exactly that kind of thing. There's not going to be any economic damages, but there may very well be non-economic damages. Now let's look at the tort of battery. Battery is where after you draw back your fist, you swing and you make contact with the other guy's nose. That is, by definition, a harmful and offensive contact. The following elements have to be proven in order to establish a case for battery: an act by the defendant, an intent to cause harmful or offensive contact on the part of the defendant, and harmful or offensive contact to the plaintiff. Now, there is an interesting doctrine that comes up in battery called transferred intent. Let's suppose that you're at a party and somebody says something really, really ugly about your wife or your child, that sort of thing, and you draw back and you go to hit the person who said it. And he ducks, and instead of hitting him, you hit the person standing next to him. Well, your intent to hit him is transferred to the person you actually hit. And even though you had no intention to hit the person who was standing next to him, you still are liable for a battery in that instance. Now let's talk about defamation. Those of you who saw the Johnny Depp and Amber Heard trial, or portions of it, probably understand the law of defamation pretty well. But here are the elements. You have to show a false statement that purports to be fact, and in that case, the false statement was the assertion that she had been the victim of domestic abuse. A publication or communication of that statement to a third person. She put an op-ed column into the Washington Post. Fault amounting to at least negligence. In her case, because Johnny Depp was a public figure, she had to establish actual malice. In other words, that it arose out of an evil motive. Damages or some harm to the reputation of the person or entity who is the victim of the defamation. Now, again, damages can be sometimes very hard to prove. There used to be distinctions in the law with regard to libel and libel per se, and slander per se. Slander per se and libel per se were the false attribution of something like criminal conduct, where you said, I happen to know that Joe Blow there is a bank robber, and he got out of prison just 10 years ago. Well, if that is a false statement and you have attributed to him the conduct of a criminal, in those jurisdictions, the damages were considered to have been proven, because that is such tremendous damage to the reputation that it just says that there has to be some amount of damage that arises out of it. But in the case of someone like Johnny Depp, he had to show that he had actually lost money or opportunities to make money as a result of Ms. Heard's statements about him. And I believe he was fairly successful in doing that. Now let's talk about a particularly interesting tort called the intentional infliction of emotional distress. This is really a hard tort to set up in terms of what actually establishes intentional infliction of emotional distress, because courts generally do not like this tort. If there is some other tort that can be applied, for example, assault or battery or fraud, then those are preferred over intentional infliction of emotional distress. And you'll understand why when I tell you what the elements are. A claim for intentional infliction of emotional distress requires a plaintiff to show, one, that the defendant engaged in extreme and outrageous conduct that was done recklessly or with the intent to cause severe emotional distress, and two, the plaintiff experienced severe emotional distress as a result of the conduct. Extreme and outrageous conduct is that which goes beyond the bounds of common decency and is atrocious and intolerable to the ordinary person. Severe emotional distress is distress of such intensity and duration that no ordinary person would be expected to tolerate it. A plaintiff is not required to show that she has suffered physical injury in order to recover damages for severe emotional distress. So this is one of those torts that, again, is hard to describe.
I went looking in Missouri for a case that dealt with the issue of intentional infliction of emotional distress, and I found this interesting case out of the Eastern District. This is a case essentially where people filed lawsuits against one another, and it all related to a bunch of trash. Let me get into it here. It arises from a lawsuit originally filed by Weber alleging that Deal had defamed him. Weber owned a sanitary landfill and a parcel of property where a proposed trash transfer station was going to be built. Now, Fred Weber Inc. is a large corporation in St. Louis. They own, among other things, a couple of car dealerships. So, as a result, Mr. Deal, who was part of a group of people who were opposed to this guy putting a trash station out there, put up a flyer, and the flyer said in pertinent part, "Stop Fred Weber Inc., the trash terrorists." So, Mr. Dunn Sr., Thomas P. Dunn Sr., believed the flyer was probably the lowest blow, the most outrageous thing ever leveled at the company in the 42 years he'd been with Weber. And because he was a little bit ticked off, he went and hired lawyers and told them to do whatever they needed to do to get this problem fixed. So 12 days after the public hearing, Weber filed suit against a company called Subdivision Fee Collectors, Inc., and the Mr. Deal, and he added him as a defendant later on. Among the allegations made were, after the September 11th attacks, the term terrorist carries with it a strong connotation of acts of injuring and killing innocent people by fanatics who hate the United States. Well, I don't disagree with that, but, I also think that he wasn't actually calling them, in fact, a terrorist. He called him a trash terrorist. So they made these false and libelous statements, according to Weber, and he sued on that basis. And he alleged that he'd suffered actual damages of $100,000 and was entitled to punitive damages of $5 million. So Deal filed a motion to dismiss, and the trial court denied it. He then filed a writ of prohibition in the Eastern District Court of Appeals. And the court there found that Weber had failed to state a claim for defamation because the language used in the flyer, particularly the words trash terrorists, was not defamatory, but was imaginative expression or rhetorical hyperbole. We reasoned that, taken in context and considering the circumstances, the flyer was distributed at a public hearing regarding a controversial issue. A reader of the flyer would not actually believe Weber was a terrorist, but would recognize the language as voicing the writer's staunch opposition to the proposed trash transfer station. So as a result, they ordered the court to dismiss the action, and then right after that, the Deals sued Weber, saying, look, you caused emotional distress, you engaged in malicious prosecution, and negligent infliction of emotional distress. And so they filed a lawsuit against him for those reasons. And in the course of that, some of the claims were dismissed and other claims were dealt with. But I wanted to cover in this segment the intentional infliction of emotional distress issue, because that is something that I think is usually fairly poorly understood, and Missouri has a rather interesting take on that particular tort. So let's get into that. In Missouri, to state a claim for intentional infliction of emotional distress, a plaintiff must plead 1, the defendant acted intentionally or recklessly, the defendant's conduct was extreme and outrageous, and the conduct caused severe emotional distress resulting in bodily harm. The conduct must have been so outrageous in character and so extreme in degree that it is beyond all possible bounds of decency, and is to be regarded as atrocious and utterly intolerable in a civilized community. Furthermore, the conduct must have been intended only to cause extreme emotional distress to the victim. Missouri courts have held where one's conduct amounts to the commission of the traditional tort and was not intended to cause extreme emotional distress to the victim, the tort of intentional infliction of emotional distress will not lie, and recovery must be had under the appropriate traditional tort action. The Deals argue that Weber's primary purpose was to cause them immediate emotional distress, while the collateral effect of filing a lawsuit was political intimidation. We disagree. According to the facts alleged in Deals' petition, Weber's primary purpose in filing the defamation lawsuit was to silence the Deals and other opponents of the proposed trash transfer station and to stop their public challenge to Weber's permit application. Notably, the petition did not allege that Weber's filing of the lawsuit was intended only to cause extreme emotional distress to the Deals. And for that reason, the court upheld the dismissal of that claim. So now you have a little bit better understanding of how that tort works, at least in Missouri, and it will work very similar to that in other states, although I don't believe most other states have the only cause emotional distress element in their definition of this cause of action.
I did a video on this next tort earlier, and I said it's one of the most difficult of the torts to prove, and that is fraud. And fraud is difficult to prove for a number of reasons, one of which is that in order to plead a claim of fraud, you have to plead that fraud with particularity. You have to nail down each of the elements, and you have to plead facts that establish each of these elements. And sometimes that can be pretty hard to do. In order to sustain an action for fraud, you have to show the defendant made a representation as to a material fact. Now, a material fact is one that relates directly to the subject or transaction at hand. For example, this is a new car, or this house has never had a leak in the roof. Those are material facts when you're buying a car or a house. The statement was false. It was known to be false by the defendant, that the representation was made for the purpose of inducing the other party to rely upon it, that the other party rightfully did rely on it, that they had a right to rely on it in ignorance of its falsity and to their injury. In other words, you're dealing with somebody who's lived in the house for 15 years. Who knows the house better than this guy? And he tells you, oh, everything's fine in the house. No, there's no leaks. There's no pipes that are the problem. All of the appliances work. And when you take possession on the first day, you notice that there are several leaky pipes in the basement, and both the refrigerator and washing machine do not work. Well, those would be fraudulent statements in that situation. It's also worth noting that in some jurisdictions, instead of having to know the statement was false, it is possible to be charged with fraud if you recklessly make a statement and you don't know whether it's true or false. In other words, you're saying everything's fine with the house and you haven't been in the house in 2.5 years. Well, clearly you don't know that everything is fine in the house. So that can also be fraudulent. Now let's look at the tort of trespass. Trespass is an invasion to another's right to possession of property. It's a direct and unlawful interference with that property. The elements of trespass are an actual interference with the right of exclusive possession, which is known as the entry element, and an intent or negligence in entering the land of another. So, for example, if you decide you need firewood and your neighbor has a tree that is something that you don't even like, it's ugly, and you decide, well, I'll just go cut that tree down so that I can get that firewood. Well, that is an intent to interfere with the possessory interest in land, and you can be guilty of trespass in that situation.
So that's an overview of the intentional tort branch of tort law, covering everything from battery to fraudulent misrepresentation. Hopefully you found this helpful, interesting, and worthwhile. We will move on to the next branch of this, which is the strict liability torts, in our third video coming up shortly.
So that's what I have for you today. Hopefully you found that useful, helpful, informative. If you did, I'd appreciate a like. If you found the content worthwhile, would really appreciate your subscription. And if you've already subscribed, again, thank you very much. More videos are just around the corner, but until then, again, please try and go out and do something nice for somebody today. Have a terrific day, and I will catch you down here at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.